Welcome, everybody. We'll give I think half our people are here so far signed up. So we'll give it just another minute and we'll get started with our presentation. Well, let's get started. So again, I just want to welcome you to our Tribal Lands webinar today and thank you for attending. We are broadcasting live from Arcata, California. This is our continuing brown bag lunch series representing the North Coast sector of the San Francisco chapter of AEP and the Redwood section of the Northern California American Planning Association. And as just a disclaimer, the views expressed today are not necessarily those of AEP or APA, but they should be. Next month, on November 10th, David Loya, the Community Development Director for the City of Arcata, will present on Arcata's Gateway specific plan. And then stay tuned for continuing brown bag lunches in the new year as well. You should also know that AEP's state virtual conference is also that week on between the 9th and the 11th of November. Also, this presentation and the previous 4 presentations have been and will be recorded and are available on YouTube for future viewing. Tomorrow, a link will be sent to you, but you can also search on YouTube for North Coast AEP/APA and see the previous recordings. This is a webinar format. At the bottom of your Zoom screen, there is a question and answer. You should use that for any kind of comments or questions. We will hold questions until the end unless I can answer them. Something to do with the presentation itself. And then before going to our presenter, Ethan Lawton, Stephen Avis has an update regarding AICP credit for our current and recent past presentations.
Thank you, Bob. So these programs are now certified for planners, AICP members for continuing maintenance programming. Each program that we have is good for 1 hour. And the series that Ethan is putting on tribal governments and interrelational governmental procedures with tribes and so forth are also qualified for 1 unit of law and 1 unit of ethics. So if you attend at least 2 of those, you'll meet your requirements for AICP as well. So with that, I will turn this over to Ethan Lawton, who is our presenter, and I'll let him do a self-introduction. Thank you very much.
Hi, just making sure everyone can hear me. All right, well, we'll go ahead and get started. Yeah. First of all, Heyang Hamalio, Hoya, Tisdale, Tawito Anote. Hello, my family, my relations. My name's Ethan Red Eagle, and it's nice to be here with you all. And so, first of all, I just want to say thanks for taking the time out of your day to join us. And I just want to take a moment to honor the Wiyot tribe as we are on their ancestral lands. At least I am from where I'm doing this presentation from. And also, I would like to start with an opening prayer. So if you'll join me. Oh, great Creator, who created all things, I pray that you be with us this morning as we learn and understand, and I pray that you help us to gain wisdom and insight so that we can get along better. Amen. Well, if you've joined our previous webinars, you know a little bit about me. If you haven't, I'll share a little bit. First, my name's Ethan, and my family's name is Lawton. My native name is Kawakbuk, but Red Eagle is a lot easier to say for most people. I come from Anchorage, Alaska, and come from 4 tribes. One of my tribes is Inupiaq from the Inuit region, and we're based in Northwest Alaska, and my family's village is Kotzebue. I'm also a quarter Sioux, specifically Lakota, and we're part of the Seven Councils Fire. I'm also a quarter Navajo, part of the Bitterwater clan. We're based in the Four Corners region, and we call ourselves Dene, which means the people in our own language. I'm also a quarter Tohono. We're in the southern Arizona region. My family's village is Gatka, and we're formerly known as Papago, but like Dene, Tohono is our own description called the people in our own language. A little bit more background. I have about 13 years as an intercultural specialist, 8 years as a tribal liaison, and I've been with SHN for about 4 years now. I've worked professionally with over 50 tribal governments and have personally traveled to over 100 reservations throughout the nation, and I have worked in some capacity with over 150 tribes. So that's a little bit of the credentials. A few disclaimers. I'm not speaking on behalf of all the tribes. This is just general information to help you kind of gain a better perspective and understanding. I do encourage you to reach out to the tribe you are working with for more details. Also, this is not intended to be legal advice. I highly recommend California Indian Legal Services, and here's their contact information for that. But with that, I do appreciate many of you who have tuned in throughout this series with the cross-cultural etiquette we did last year, and the tribal sovereignty and tribal government we did earlier this year, and the tribal consultation we did recently, and this is the tribal lands. Next year we'll be discussing tribal cultural mitigations and tribal confidentiality. Here is what we're going to be covering today. It's going to be a lot of information. I'm only given an hour, and I could easily spend quite a few days on all this, so I tried to boil it down to just the essentials, but it may seem like a lot of information for you. Feel free to reach out to me by email and let me know if you want the PowerPoint or anything like that. I'd be more than happy to send that to you. But I'll give an overview of tribal history. I try to think of the easiest way to cover everything with tribal lands, and the best way that I found to explain it is to kind of go through the course of history and how tribal lands has been regulated and how it's changed and been impacted. So I'll cover the history, and then at the end, I'll have an illustration to kind of really drive home everything that we've talked about, and then I'll be open for questions and answers at the end. So before I get started, here is this video, and I wanted you to gain a more understanding of how the states kind of spread throughout from the west, from the east towards the west. And slowly you're seeing these regions become territories. And over the course of time, you can see the years at the bottom. These territories slowly become states. And it's sometimes interesting to see the process of this spread. We often think of the states have always been there, but we know they always haven't. And so it's interesting to see the progression from the East Coast to the West Coast. And it's quite an interesting process. And I'm including this because we'll discuss kind of how the land policies have impacted tribal lands and the different regulations the federal government has taken. And so we're seeing we're kind of getting closer to present day as we're getting close to the 50 states. Almost there. And my home state, Alaska. Yeah. So I wanted to show that to help gain a perspective. So as you can see, there's this timeline at the top, and I have a few dates up there, and you can see I wanted to cover pre-1492, and I want to focus on philosophy, different perspectives on land. So on the left side, you'll see tribal versus American perspective. These are just some general concepts I put together for you to help understand the difference. And then on the right side are some quotes. The first one I want to mention is tribal perspective on land is that it's creation by a creator. There's a quote from Big Thunder about the Great Spirit is in all things. And he is in the air we breathe. The Great Spirit is our father, but the earth is our mother. She nourishes us. That which we put in the ground, she returns to us. And so we see that tribes view earth as creation from the creator. And so that's one of the perspectives that tribes have on land. Another one is that tribes view themselves as the original inhabitants, as opposed to being migrated. A quote there from Lakota is, "We have been here, and our creation stories have taught us that we have been here since time immemorial." And so we see that they come from the land and are returned to the land. And so there's that connection and cycle that is important in regards to the land. Third is that tribes have a perspective on created equal, in the sense that the land is viewed as creation just as we are creation, so therefore on the same level of value. A quote here I have is, "You asked me to plow the ground. Shall I take a knife and tear my mother's bosom? You asked me to dig for stone. Shall I dig under her skin for bones? You asked me to cut grass and make hay and sell and be rich like the white men. But how dare I cut my mother's hair? Then when I die, she will not take me into her bosom to rest." And the principle I want here is the different perspective on how land is essentially like on an equal basis as people. So that's often a perspective that tribes have. Another one is spiritual. It's not just physical. The land is not just physical, tangible stuff, but it's also spiritual. Here's a lengthy quote, but it's important, from Chief Seattle. "Every part of this earth is sacred to my people. Every hillside, every valley, every clearing and wood is holy in the memory and experience of my people. Even those unspeaking stones along the shore are loud with events and memories in the life of my people. The ground beneath your feet responds more lovingly to our steps than yours, because it is the ashes of our grandfathers. Our bare feet know the kindred touch. The earth is rich with the lives of our kin." And so we see that land is not just physical. There's a spiritual and emotional component that tribes hold to with land. Another point is that there is a certain connection. A quote here from the Ojibwe is, "We are part of everything that is beneath us, around us, above us and around us." And so everything is connected. So when one thing is disrupted, it throws the whole thing out of balance. And that's why a lot of tribes have dances and rituals and beliefs and concepts about maintaining the balance. And so when something throws it off, we see that it's all connected. Another point is that land is a shared mentality. Chief Joseph said, "The earth is the mother of all people, and all people should have equal rights upon it." Chief Crowfoot said, "Our land is more valuable than money. It will last forever. It will not even perish by the flames of fire. As long as the sun shines and the water flows, this land will be here to give life to men and animals. And so many tribes hold the concept, or at least used to, that the land is the creator's, and there's enough room for all of the creator's children. And then lastly, there is a stewardship component. I have a Cheyenne quote here. The old Indian teaching was that it is wrong to tear loose from its place on the earth anything that may be grown there. It may be cut off, but it should not be uprooted. The trees and the grass have spirits, whatever one of which growth may be destroyed by some good Indian, his act is done in sadness and with a prayer for forgiveness because of his necessities. In other words, there's an honorable approach when it comes to land. And so these are just some different perspectives that I wanted to bring in. Again, I could spend all day talking about these different philosophies, but I wanted to bring this to mind as we discuss policy and land from an American perspective. So as we enter into the 1492 era, there's different eras, and I titled this one Tribal Independence. This is when two worlds merged. And in 1607, Jamestown was founded in Virginia. And these were from people from all over the world. I mean, England, France, Spain, the Netherlands. Yesterday, was the federal holiday of Columbus Day, and many people and numerous tribes celebrated Indigenous Peoples Day. And so this was an era where the worlds merged. Not only that, but there was wars. There was numerous wars, the French and Indian Wars, the Spaniard Wars. There's the American Revolution took place in this era. And tribes were on all sides of those wars. Then we enter into the agreements between equals era. The first treaty that was signed by the US and a tribe was right after the adoption of the Constitution, and it was with the Delaware Indians. And then right after Congress met, I believe it was the third Congress, they passed the Northwest Ordinance, and they stated that the utmost faith shall always be observed towards Indians. Their land, their properties shall never be taken from them without their consent. And then in 1793, Congress placed limitations and restrictions on non-natives in regards to tribal lands. And so there was this agreement as equals because the United States was a new nation, and tribes at that point were nations with sovereign nations with large standing armies. And so the federal government viewed tribes as an equal and entered into agreements and treaties and honored the lands that the tribes held. Then, as the colonies and states began to expand, we entered into the Relocation Era. In 1830, President Andrew Jackson encouraged Congress to pass the Indian Removal Act, and that's exactly what it was. It removed Indians from reservations and lands east of the Mississippi towards the west of the Mississippi. Most of them were relocated towards what is common day Oklahoma, and that's why there's so many tribes in Oklahoma, was because of the Indian Removal Act. So all the treaties, all the agreements were all broken. Many are familiar with this and know this as the Trail of Tears. This is due to the Relocation Era. Then we enter into the different gold rushes. One was in California in 1848 and the other in South Dakota. And then Congress prohibited additional treaties in 1874. And treaties are the basis for land, and that's why I included it in here, and land was taken away, which is also why I included it in here as well. Then we enter into the allotment and assimilation era. In 1887, Congress passed what's called the General Allotment Act. Many of you may know this as the Dow's Act or the Daves Act. And this was a real hitter towards tribes. In each of these eras, it's kind of like a pendulum that the federal government has taken in regards to tribes, some more favorably and some more detrimental. And so the pendulum swung a few times, and this era, it swung towards the detrimental part of tribes. And this General Allotment Act extinguished tribal sovereignty. It erased reservation boundaries. I think like 109 reservations were terminated. And tribal members were assigned an allotment. And after 25 years of trust period, it will then be overturned to for the natives to manage themselves. And any excess lands were sold to non-natives. And so originally the reservation was held in trust for the tribe in general. But because of the General Allotment Act, that reservation was divvied up into lots, and each were assigned to individuals. But the thing with natives holding individual allotments was this was a foreign concept. There was no prior knowledge or experience or even guidance to maintaining a personal allotment in regards to taxes and filing and different things like that. And so this forced a lot of individual allotments to be placed on the market and sold to non-natives. And so over this period of time, over 100 million acres were lost from the original allotments. And so we see this different tiered approach of land. And this was one of the most known tiers of loss of land in the allotment era. And I'll go more in depth on this later. But then the pendulum swings in favor of tribes in the Indian Reorganization Era. In 1928, the Brookings Institute produced the Merriam Report, which was based on the visit of 95 reservations. And they included like the current status of things and some recommendations and approaches to improvements. And as a result of this report, in June 1934, Congress passed the Indian Reorganization Act. And this is commonly known as the Wheeler-Howard Act. And what this did was this combated the General Allotment Act, where the General Allotment Act was positioned with the intention of gaining more tribal land to non-tribal members. The Indian Reorganization Act flipped that and said that tribes can now purchase land, and that whatever current land is now protected, and that new reservations could be created and restored land. All 109 tribes that were terminated were then reinstated throughout this process on the basis of the Indian Reorganization Act. And this allowed tribes to gain back an additional 2 million acres. Not quite the 100 million that was lost from the general allotment, but it's better than none. So 2 million acres were regained back. Next, we enter the Termination Era. So just as the pendulum swung in favor of, we see it swing back towards the detrimental. And the Hoover Commission produced a report that called for the complete integration of natives. And so as a result, in 1953, Congress passed a resolution to dissolve the trust relationships between the federal government and tribes. And so Congress started terminating tribes. And where it couldn't terminate, it sought to eliminate the land. And whenever the land was taken from the tribes, it was given to the states. And also in ties with this, in 1953, Congress passed what's known as Public Law 280. And so we see this where land couldn't be taken, then jurisdiction was taken away. And so Public Law 280 applies to criminal and civil jurisdiction over reservations. And this is here in California. Every reservation is under Public Law 280. And so I won't dive into depth about criminal and jurisdiction, criminal and civil jurisdiction too much, but I will say that it depends on if the perpetrator is native and the victim is native, or if the perpetrator is native, non-native, and non-native to native, and then a non-native to non-native, either within the reservation boundary or outside. These are numerous factors, and again, I could spend a full day talking about criminal and civil jurisdiction, but I mainly just want to talk about policy and procedures. And so with the limited time that I have, I'll go over that. So then we enter the tribal self-determination era. And this includes up to present day. There are numerous presidential quotes which support the self-determination of tribes. And there are numerous quotes by Lyndon Johnson, Richard Nixon, Ronald Reagan, Bill Clinton, Barack Obama. All of these presidents took a pro-tribal sovereignty, and if you were a part of the tribal sovereignty presentation, you got a healthy dose of that. And so we see that the federal government pendulum swings again in favor of tribes. And a lot of times this is why tribes have trust issues with not only just the federal government, but any government in particular, even including local governments. It's because the pendulum has swung back and forth so many times and so many promises made and not very many promises kept. And so please understand that's why some tribes have trust issues. And in 1968, Congress amended Public Law 280 and protected tribal rights in regards to criminal and civil jurisdiction. And in 2009, the United States affirmed the United Nations Declaration of the Rights of Indigenous People. More on that later. So many have heard the term Indian country. So what exactly is Indian country? Well, I'm so glad you asked. All land under the supervision of the U.S. government that has been set aside primarily for the use of Indians. That's what Indian country is. Basically, all land within Indian reservation boundaries and all lands outside of the reservation that are placed under federal control that is designed primarily for Indian use. So this includes land that is in trust, fee, or reserved for Indian use. So that this decision is, whether it's Indian territory or not, is an issue of law. And so it's a determination of the judge. And so that's an interesting component that many may not know. So reservation remains Indian country unless Congress eliminates the reservation. So Congress gets to determine, and the judicial branch gets to interpret. And so many of you may remember that from the sovereignty presentation. So Indian country, here's where it's codified, are broken into three different buckets. And the first bucket is that all lands within the reservation boundary. including right-of-ways. And so anything within the reservation boundary is deemed Indian country. In the second bucket, we see that all independent communities within borders of the United States, whether original or subsequently acquired territory thereof, and whether within or without the limits of the state. So in other words, if it's dependent, the key word is dependent here, then it's deemed Indian country. And then all Indian allotments and Indian titles to which have not been extinguished, including the right-of-ways running through the same. And so there are allotments and titles, and those are different. And I'll touch on those in a little bit. So some may ask, well, what about reservations, and what is a reservation? A reservation is land that has been set aside by the federal government for the use and benefit of one or more tribes. So some tribes have a reservation all to themselves, and some tribes have to share a reservation with other tribes. And so we see that some reservations reflect the name of the tribe, and some reflect a name unaffiliated with the tribe. And some tribes take on the name of the reservation itself. And usually that's a result of the Indian Reorganization Act. Most reservations were created by some formal means, such as a federal treaty. However, treaties ceased to be ratified in 1871. And then some reservations are created by statute of Congress or even by an executive order from the president. However, that stopped in 19 something, I forget the date. The terms Indian reservation and Indian country are often used interchangeably, but they are in fact different. Indian country includes an Indian reservation, but Indian country goes beyond the reservation boundaries. And so these are different in reports and in descriptions. And so it's important to know the difference between a reservation boundary and Indian country land, especially in this day and era. And then there's Indian title. There are 4 buckets in this realm. The first is the federal government acquired ownership of all land within the United States by discovery and conquest, that the Indians lost all rights and ownerships. So in other words, the federal government holds all the lands by default. And this is in regards to today. Indians retain a perpetual right to remain on their Aboriginal territory until such time as Congress decides to take this land for another purpose. In other words, in regards to all tribal land, Congress is the final say. I cover this elaborately in the tribal sovereignty webinar. The third bucket is Indian title is a possessory and not an ownership interest unless Congress gives them ownership rights. So in other words, it's default Congress unless Congress says it, the owner is either the tribe or the individual. And Indian title may not be sold by Indians without authorization from the federal government or loss or removal except by the express act of Congress. And so in other words, because Congress is the final say, if Indian title land, nothing can happen to it without Congress's approval. And as a result of this, many allotments enter into what's called a 99-year lease. So in other words, the ownership doesn't change, it's just leased for 99 years, and then after that, it goes back to the owner. And so that's part of the Indian title. So many may wonder about, what about the land that was lost? And what about the money that tribes are receiving? And some thinks that those are different but in fact, those are tied together. Embedded in the US Constitution, there's such thing as land compensation. And many of this goes back to the treaties that were signed and agreed to between tribes and the federal government. But this goes back to the recognized and unrecognized tribes. Within the Constitution, there's what's called the Due Process Clause. In other words, land can't be just taken. There's a process. And then there's also the Just Compensation Clause. In other words, there has to be a fair price that's paid for the land if the federal government takes it. The federal government can't just take land and say, oh, here's $1. They have to figure out what's the just compensation for it. Here's an example I included for you. The federal government took the Black Hills in, I forget what date, from the Sioux, and the federal government decided it was worth to them about $100 million. And so they offered this to the tribe, and the Sioux tribe said, we don't want the money. We want our land, the Black Hills. And so to this day, the tribe have not taken the $100 million. It still sits in the Federal Reserve. And to this day, the federal government still retains the Black Hills. And so that's a current example of that. And that has happened to numerous tribes where the federal government will take land and will give the tribe the just compensation according to the federal government. And again, many of it goes back to the treaties. Most of the treaties were, you give us most of this land, we'll reserve this portion of land for you and the tribe to dwell. And the federal government will make sure that you are taken care of, that you're fed, that all the services are met, that you're happy, and that you'll live peacefully. And so that's what all of the treaties were done. And in 2010, the US supported the United Nations Declaration of Rights for Indigenous Peoples. And in Article 26, it states that Indigenous peoples have the right to own, use, develop, and control the lands, territories, and resources they possess by reason or traditional ownership or other traditional occupation or use, as well as those which have otherwise been acquired. So then there's the trust relationship. Many people have heard like trust land or the trust responsibility or the trust relationship. So you may ask, oh, what is all this about? Well, nearly 400 treaties were signed between the US and tribes between 1787 and 1871. And sadly, all 400 of these treaties have been broken on the federal US government side. But these treaties were created essentially out of trust. And I have a few quotes, one from the Cherokee Nation. The federal government entered a treaty with the Cherokee Nation in 1785, and it guarantees peace to all Cherokees and promises to receive them into the favor and protection of the United States of America. And then there was a treaty with the Navajo Nation and the federal government in 1849. And it guarantees that the tribe, in exchange for the land it was relinquished, would be placed under the exclusive jurisdiction and protection of the government, and that the federal government would ensure the permanent prosperity and happiness of said Indians. And so we see that the treaty embedded this trust relationship. In other words, that the federal government promised that it would take care of tribes in exchange for land. And so the federal government has a duty to fulfill its promises that was made. And this is known as the Doctrine of Trust Responsibility. And so when a land is held in trust, it means that the federal government is holding that land for the benefit of the tribe. And a trust property can be viewed essentially as the same as like a trust fund. There's the person or entity who holds the trust property is called the trustee, while the person from whom the trust is created is called the beneficiary. Just as the trust fund is set up and whatever board or entity or organization is managing the trust fund, they are to do everything in the favor of the beneficiary, which is, you know, that person's son or daughter or anything like that. And so that's how it is with land. When land is in trust, the federal government is the trustee and the tribe is the beneficiary. So the federal government is mandated to do everything in the best interest of the tribe, the beneficiary. So here is some language that I included regarding the trust doctrine. The US Senate made a statement in 1977 basically saying that the federal government is obligated to uphold their promise and their I guess their protection and ensure survival of welfare of the Indian tribes according to the treaties. And then the Supreme Court in 2000 said that Congress must fulfill its treaty obligations and its responsibilities to Indian tribes by enacting legislation dedicated to their circumstances and needs. And so here is an illustration that I put together to really help drive home everything that we just talked about and how it applies to tribal lands. So this gray box is just land. And so the land was there, and then the federal government stepped in and said, hey, we would like this land, and made a treaty with the tribe and said, we'll set aside this little, we'll reserve this plot of land here for the tribe. The federal government will take care of the tribe in exchange for all the other land. And so the tribe agrees to this, and this is the reservation. The red box is the reservation boundary, and the darker gray is reserved for the tribe itself. And then all the rest is for the federal government to do as deemed. Usually became a territory, then a state, and then is under state jurisdiction, and everything within that reservation boundary is exempt from that state, county jurisdiction, and it's all federal. Then because of the General Allotment Act, it freed up allotments within the reservation for non-Indian owners. And so these are subject to state and county regulations. And so this is what's called checkerboard effect. And so there is land that's the dark gray that's held in trust. And then there's land that's light gray that's held in fee or simple fee. Then, as a result of the Indian Reorganization Act, the tribe was allowed to buy some of that land back. There are still some allotments that are not tribally owned, but most of it has been returned back or purchased back. Then the Indian Reorganization Act allowed tribes to purchase lots outside of the reservation boundary. And so the tribe purchases various lots outside of the red reservation boundary. And then also because of the Indian Reorganization Act, the tribe can place some of those lots into trust, just like the land within the reservation boundary. So you can see that those two adjacent to the reservation boundary was converted to trust, while the outside three are still in fee. And there is a conversion process that the Department of Interior goes through, and it's a really rigorous process, and there are 9 strict criteria, and the tribe needs to meet all 9 perfectly. And so tribes can place fee trusts into land. They can grow land that is the tribes. And so that was an illustration that really drives home the point of the confusing process of land. And in regards to land use, in closing, it's definitely been a developing policy, but everything within the reservation boundary is typically regulated by tribes. Tribes can prohibit any certain activities on fee land, but they can't regulate fee land within reservation boundary. Within reservation boundary, if it's trust, they can regulate it, and it's exempt from county and state policies, but still subject to federal. And it creates unique zoning issues. Tribes are starting to develop their own general plans, master plans, and different things like that, different zoning ordinances. And so we can see how this all plays a role and different things like that. And there are different overlapping, that's the difference in overlapping of jurisdiction and authority, and how your project may land on either the fee or a trust, or inside the reservation or outside of the reservation boundary, and how all of that plays a role in everything. And with the time that I have, that is a brief summary. Again, I didn't cover criminal jurisdiction. I didn't cover taxes. I didn't cover fishing or hunting rights. I didn't cover water rights. I didn't cover gaming rights, let alone civil rights. And so when your project is within the reservation boundary, it's typically subject to TARO, taxation and TARO rights. And when you develop contracts, sometimes there's a clause in there that you would be subject to the tribal courts. So that's something to be aware of as well. And that's a brief summary of tribal lands. And I believe I have 10 minutes to answer any questions.
Sorry.
Because I am sharing a screen, I can't see any of the chats and stuff. And so I'll have Bob or Steven kind of share any questions or comments or concerns, but here's my contact information. Feel free to email me for the PowerPoint, or if you have a suggestion, feel free to reach out. I'd be more than happy to help with any concerns or specific things that you or your project may entail. But with that, I don't know if there are any questions.
Indeed, there are, Ethan. A couple on rancherias, but one of the questions is, can you provide a quick thumbnail of the Yurok and Karuk tribes, the local rancherias and the Hoopa Reservation, to exemplify how they fit into the different types of tribal lands?
I don't know what is meant by a thumbnail, but yes, one, it changes every day. Both tribes are, the land base is changing all the time. But in brief, the Hoopa and Yurok were placed on the same reservation, and then the federal government realized that they were two separate tribes and then created two separate reservations, and what is now Yurok Reservation and Hoopa Reservation, which was formerly the Klamath Basin Reservation, I believe. The Karuk was not properly set aside a reservation by the federal government. But since then, all three tribes have land and trusts, and there are lands with fee within the reservation boundaries for the Yurok and Hoopa. And then the Karuk has gained land, and I forget the other tribe that was mentioned. But if you could email me independently, I could definitely answer that question a lot better, but that's the gist of it.
You covered the three tribes, but the other question was, you know, in the Yurok territory, there are a number of rancherias. How do they fit in with that, with the tribe?
Yes. I forgot to include a slide on here on rancherias. Basically, there are different types of reservations. One was initially created by the federal government, and then there are others that are honored by previous governments. In other words, there are land designations that are honored from the Spaniard conquest that tribes made with the Spaniards, and then the US government honored those. With the Mexican government, tribes made land agreements with the Mexican government, and then when the states grew towards that, they honored those agreements as well. Those are known as pueblos. But typically rancherias are unique to California or Southwest area, and they were initially created to house tribes that wouldn't go to the reservations. And so usually rancherias are made up of a mix of historic tribes. I discussed that briefly in a previous webinar. And then, so rancherias are kind of a different class, and there are unique reservation situations, like with the Navajo reservation. There's a reservation within the Navajo reservation, and that's the Hopi reservation. Just like there's the Rezagini Rancheria within the Yurok reservation boundary. So there are definitely, there's no clean cut. Land is messy, especially with the federal government position with tribes. And so it's unique. I'd be more than happy to help clear up anything. If feel free to email or call me, and I can provide more clarity and additional guidance on that.
So with rancherias and reservations, are there any differences under federal or state law?
There are no differences. Both are, the difference is why it was created. Other than that, they're both typically in trust. They're both immune to county and state regulations in that sense. And then typically both are run by a certain tribe, one by treaty or agreement, and another by the Indian Reorganization Act.
Okay. Another question would be, like, for a local agency, can you just explain the difference between fee and trust land?
Yes. For a local agency, fee land is subject to county and state regulations, and trust land is immune to county and state regulations, but is still subject to federal regulations. For an example, if a project is purely done on trust land, then it's subject to NEPA requirements and Section 106. If it's purely on fee land, then it's subject to CEQA requirements and AB 52 regulations. And so we see that there's a difference in some projects take place on both, and that's where it can get pretty dicey. But that's the difference for local agency.
So what about reservations, rancherias, and then we get into in sequa the tribal cultural resources? How does that differ from the boundaries of?
Can you repeat the question?
Yeah, so CEQA requires addressing tribal cultural resources.
Mm-hmm.
So how do we address those compared to when we look at rancheria or reservation boundaries? Do they go beyond those boundaries?
Great question. Yes. So this goes back to the ancestral lands, and tribes roamed everywhere. And so there's cultural resources and importance, significance outside of the reservation boundaries. The reservation boundaries are recent in history. And so tribes have concerns beyond reservation boundaries. And that's why AB 52 was added, because they realized that tribes know a lot more than archaeologists, and about what's culturally significant to the tribe. And resources aren't limited to reservation boundary. It's just that tribes are currently, but they haven't always.
Okay. Another one is regarding some of the allotments that may have transferred out of tribal ownership in the past. Are they still considered sovereign lands? Are they similar to fee lands as far as local regulations?
If they are not in trust, in other words, held by the federal government, it is not sovereign land. If it's held in trust by the federal government for the tribe, then the tribe has sovereign jurisdiction over it. And in my sovereignty webinar, I explained more about what sovereignty means, what limits, and different things like that. But if it's owned by an individual in trust, then it's sovereign to that individual and protected by the federal government, held in trust. If it's in fee, it's not sovereign, whether it's held by either an individual, an entity, or the tribe. If it's in the reservation boundary, then everything is on the best interests for the tribe, and that's how federal government views it, and that's how local governments should also view it as well, because it's within that area specifically reserved for that tribe. And earlier in the presentation, I covered why it should be protected. So.
Okay, well, we have 1 minute left and one more question. Just a yes, no. As far as you mentioned the pendulum going back and forth, is there a concern that the pendulum may swing back away, disfavoring Native Americans?
I think I speak for most tribal people in the sense that we can say with confidence that the pendulum has always swung, and we would not be surprised if it continues to swing. Most tribes would like it to continually go towards in favor of, but we're definitely not holding our breath. Just ask any tribal person. There's not much faith in the government. We do what we can now and hope for the best.
All right. Well, thank you, Ethan, for doing this. Again, this will be placed on YouTube, and we will send out the link to our participants today. Thank you for attending. Hope to see you again next month.